All right, good afternoon, everybody. Welcome to the opening event of the Petrie-Flom Center's 2019 to 2020 academic year event calendar. I think I see a lot of familiar faces, so most of you are well aware that we keep events and facilities at HLS very, very busy. We're very good returning customers. We have a lot of events coming up in this semester and the following semester that we think will be really exciting. Please keep your eyes and ears open for these coming events. The best way to do that would be to sign up for our newsletter. It comes out only twice a month, so it's not going to spam your inboxes. And you can do that by going to our center website and scrolling all the way down to sign up for our listserv. If you like book talks, we can definitely satisfy that itch because next week, on September 16th, we have a book talk for our book on transparency in health and healthcare in the United States. This is an edited volume coming out of one of our annual conferences. It'll also be a really exciting discussion. Then we have coming up on December 6th, our 8th annual year in preview, which looks at both health policy stories that were big and interesting in the past year, as well as what we think is going to be big in the coming year. So that's a series of rapid fire talks and panels. It's very topical. It's really fun. In between that, we're bringing 2 Mexican Supreme Court justices to campus to talk about abortion jurisprudence in Mexico, as well as we're partnering with a variety of other programs to talk about PEPFAR, which is the program that provides low-cost HIV drugs to the global south, primarily in Africa. And that will be on October 7th. In the meantime, a few housekeeping things. The most important thing, bathrooms. Go out, make a right, and you've got your bathrooms right there. After this talk, we have our open house, and we strongly, strongly encourage all of you guys to come. We have snacks. More importantly, we will buy you guys all a drink. So better than a pizza lunch, even. And we'll introduce ourselves a little bit more, as well as some of our sister centers and programs around Harvard. It's a great way to understand all of the resources that are available here, as well as just have a casual drink with some cool people, Glenn, myself, but more importantly, the rest of the Petrie-Flom community. But you guys are here for the book talk. We are going to be discussing Dov Fox's Birth, Rights, and Wrongs. I'm going to keep this very short, because I think the quality of this panel will speak for itself. But first of all, we have the author himself, Professor Dov Fox, who's going to give some remarks on this project. And he is Professor of Law and Director of the Center for Health Law and Policy and Bioethics at the University of San Diego School of Law. Then we're going to have a panel respond with their reflections of kind of thoughts that occurred to them as they read this book. And first, we're going to have Katie Krashel, who is a former Petrie-Flom student fellow. So for those of you who are incoming 1Ls who are checking us out, or maybe 2Ls who haven't become Petrie-Flom student fellows, a plug to consider that program. And she is a lecturer in law, clinical lecturer in law, research scholar in law, and executive director of the Solomon Center for Health Law and Policy at Yale Law School. Following her will be Louise King, Assistant Professor of Obstetrics, Gynecology, and Reproductive Biology at Harvard Medical School. And then last, but certainly not least, will be our own faculty director, Professor Glenn Cohen. And so with that, I won't take up too much more time from the substantive portion of the day. So let's welcome Dov to the stage.
Well, thank you so much for that introduction. And Glenn, for an awfully good time yesterday engaging with your health law students. It is wonderful to be back at Harvard among so many friends and fellow travelers. This is where I fell in love with bioethics and the law amidst revolutionary advances in reproduction. From long-lasting birth control to babies conceived in Petri dishes and genetic screening early in pregnancy using nothing more than a simple blood test. This is the medicine of miracles. It fills empty cradles, frees family from terrible disease, and lifts pregnant and infertile people onto more equal footing. But it's never been well regulated, and accidents happen. A lot. One of the many couples I talked with are Janet and Wendy Norman from Peachtree, Georgia. They were looking to start a family, but they needed working sperm. So they pored over hundreds of anonymous profiles, finally settling on donor 9623. The sperm bank, called Zytex, cast him as a Tom Cruise look-alike, but half a foot taller. The 26-year-old neuroscience engineering PhD student was an internationally acclaimed drummer who played 5 sports and spoke 4 languages. He boasted a love of nature and an IQ of 160. The Normans wired Zytex $3,000 for 6 vials of his sperm, and a year later, they had a boy, let's call him Henry. He was 12 when Zytex leaked his donor's identity. It turns out he was nothing like the Normans were led to believe. When they Googled his name, the first thing that popped up was a public court document that showed he'd been convicted of burglary and dropped out of college after a history of serious mental illnesses, including schizophrenia. That gave any offspring he had about a 1 in 8 chance of having it too. And Henry wasn't the only one. There are 35 other progeny of donor 9623. Other mix-ups rob people of the ability to reproduce at all. These are cancer survivors, injured veterans, and same-sex couples who pay tens of thousands of dollars for painful medical procedures in order to make it possible for them to have a child of their own flesh and blood. Fertility clinics keep their dreams of biological parenthood on ice in big vats containing thousands of reproductive materials from would-be families.
The incident at Pacific Fertility Center in San Francisco happened on the same day as University Hospitals in Cleveland. The level of liquid nitrogen in a cryo-storage tank used to preserve eggs and embryos dropped, raising the temperature in the tank and putting the eggs and embryos at risk.
This wasn't the first time. Freezers failed in 2012 at Northwestern Hospital in Chicago, and in 2005 at the University of Florida Medical Center in Gainesville. Reproductive errors also happen to people who are trying not to have kids. In 2015, more than 100 women found themselves pregnant when their birth control pills were found to be packaged wrong.
For generations, women have relied on the pill to avoid pregnancy. But a new lawsuit says 8 brands of birth control pills failed, putting 113 women in danger of unintended pregnancies because the pills were defectively and dangerously designed, manufactured, packaged, sold, and distributed. The defendants, Endo Pharmaceuticals of Ireland and its subsidiary Qualitest, based in Pennsylvania. The suit alleges the pills were packaged upside down, reversing the order. So the placebo pills were taken at the start of the women's 28-day cycle rather than the end. And that left the women without adequate contraception and at risk for unwanted pregnancy.
This isn't an isolated incident. It was the 4th nationwide recall of birth control pills in just the last decade. And these calamities aren't unique. A recent survey of U.S. fertility clinics found that more than 1 in 5 had lost embryos, switched donors, or contaminated samples. The problem is there's no meaningful federal or state oversight of reproductive medicine. And professional guidelines are completely voluntary and routinely ignored. Nail salons and toasters are better regulated. And courts don't do anything after the fact either. They say that reproductive negligence falls through the cracks of existing protections under the law of torts or contracts or property, leaving judges to throw up their hands. The Supreme Court of Tennessee explained in 2005, quote, "The law does not recognize the disruption of family planning, either as a cause of action or as an element of damages." This puzzling void is what motivated my deep dive into this body of law. My inquiry turned up three very different kinds of controversies. Some, like the freezer malfunctions, leave desperate couples with no baby. Other cases, like the busted birth control, hand individuals the very baby they tried to avoid having. Others still give people not just any baby, but one whose particular genetic traits are different than the ones they had chosen. Where lawmakers neglect these injuries, I argue that courts should step in to vindicate the reproductive interests at stake. It's been a century since judges last flexed their common law muscles to create now familiar rights to privacy and libel and informed consent. The time has come to recover that muscle memory and establish three new rights of reproduction. I call these procreation deprived, procreation imposed, and procreation confounded. Let's start with procreation deprived. The facts vary. It's not just labs that lose people's embryos. You might have heard about the clinic this summer that implanted them into the wrong people. In other cases, a pharmacist swaps a prescription for prenatal vitamins with abortion pills. Or an obstetrician tells a woman that the healthy pregnancy she longs for is too risky for her to keep. Victims who sue in these cases always lose. For one, they were never promised a baby to take home. And however devastating their loss, they can't point to the kind of physical or economic injury that the law typically requires to hold the floodgates of litigation at bay. Judges also say that victims can still adopt. And it's not like the error left them any more childless than they were before it. But for those who want to reproduce, being denied that chance is a real and substantial injury. This is the memorial that people who lost their eggs and embryos in one of the two most recent fertility tank malfunctions had inscribed on a cemetery bench outside of Cleveland. We toiled to get you. We celebrated to have you. We wept when we lost you. We'll never forget you. Dedicated to the memory of our hopes and dreams lost. These losses deserve a remedy. Courts face very different questions when procreation is imposed. That is, when doctors fail to diagnose an unwanted pregnancy until it's too late to safely or legally end it, or when they botch a vasectomy or leave tubes untied, or when contraceptive rings or patches don't work how they're supposed to. In these cases, courts are suspicious of people who forgot to use a condom and are now trying to make someone else pay for their own reproductive recklessness. But corroborating evidence can weed out sham suits. Judges also press plaintiffs. If you really didn't want a baby, why didn't you just do something about it? These courts would condition remedies on an abortion or adoption that victims wanted even less than being pregnant in the first place. But that only exacerbates the reproductive injury they've already suffered. Other courts in these cases express a deeper kind of concern. Even if you didn't plan on having a baby, they say, once you hold him in your arms and hear him coo, how could you not appreciate him as a gift and a blessing, one who makes your life better, not worse? This objection purports to sound in the register of parental love. But listen closer, and you'll hear misplaced mother shaming. Standing up for your reproductive interests doesn't mean you love your child any less. And loving the child that you have doesn't mean you weren't injured when procreation was imposed. Finally, our thwarted efforts to choose a child's features. This third group is the most controversial one, least familiar. The group involves people who wanted a baby and got one, except an embryo switch or misdiagnosis gave them a baby who's not genetically related to them or not free of the disease that they took careful measures to avoid passing on. Judges deny remedies in these cases too. They fear sending an intolerable message that parents wish their own child had never been born, or that people with the condition that parents targeted are too defective in their very DNA to justify their existence. Courts conclude, we are unwilling to say that life may ever amount to a legal injury. And accordingly, they wholly forbid these claims as no less than eugenic. But these parents aren't trying to eliminate people with disabilities. They're making heart-rending decisions in a society that's often inhospitable to vulnerability and difference about whether their family has the wherewithal to care for a child with particular needs. Courts that are willing even to entertain these grievances, usually under the pejorative of wrongful birth, usually insist that damages are too speculative to award anyway. They say it's impossible to predict how a baby's life will turn out, even more so how his arrival might impact his parents. Well, sure. But just because we can't calculate the harm of confounded procreation with any kind of precision doesn't make it any less harmful. That reproductive injury is, moreover, no more difficult to define than the loss of life that courts remedy all the time in cases involving wrongful death, or the loss of liberty in cases about wrongful conviction, or the loss of dignity in wrongful imprisonment. Courts should determine awards for reproductive injuries in two steps. First, they should ask, to what extent was the misconduct to blame? For example, fertility patients might not have ended up with a baby even if they got perfectly competent care. But they had a chance. The lab that destroys their embryos should be responsible, not for the loss of a child, but for whatever chance of reproducing its negligence robbed them of. The second question courts should ask has to do with the severity of that injury. Think of a workers' compensation table that breaks down the harms based on objective facts that makes them more or less serious. So the permanent denial of procreation warrants greater rewards than a temporary one. And foisting a baby on a single mother who's forced to give up her education calls for less than the same would for a married couple with already established careers. Likewise, some thwarted conditions are more debilitating than others. These harms may also be offset by countervailing benefits. American judges should look for guidance abroad. Singapore's highest court recently found a fertility clinic liable for switching a husband's sperm with a stranger's. The justices awarded about $80,000 for that loss. That's far less than had the child been born with a disease that the couple had tested for. And that total was, I think, appropriately offset by the profound joy that the IVF mix-up simultaneously brought them. The court called this the hardest case in its history, even though the decision was unanimous, in part because the couple discovered the mix-up only because their child was born with much darker skin than either of them had. There's no easy way to resolve these controversies. They implicate matters as profound and intimate and divisive as race and family and life itself. But vindicating the critical interests at stake demands this delicate case-by-case balancing. We shouldn't be resigned to an absolute immunity that lets badly behaving specialists off the hook and leaves those in need of reproductive help to assume the risks and steel themselves against its aftermath, no matter how it upends their lives. This brings us back to the case of donor 9623. The Federal Court of Appeals for the 11th Circuit condemned the sperm bank, Zytex, as reckless, reprehensible, and repugnant for failing even to ask the donor for any medical records or criminal history, let alone a school ID. And yet, the three-judge panel refused to recognize the negligent thwarting of offspring selection as an injury under the law. Tell that to Henry's parents.
The rage started early, collapsing on the floor in kindergarten, not responding to anyone, screaming fits in first grade with signs of bipolar disorder, disappearing into the woods in third grade.
And then we found on his phone that he was searching how to kill myself and how to kill my perfect stepbrother.
But it wouldn't be until March of 2017 that Wendy Norman would discover her 15-year-old's behavioral and mental issues likely tied back to his birth and sperm donor number 9623.
For me, I'm scared. How do I help my son?
They should have been entitled to recover. We're used to blaming bad luck or cosmic injustice when we don't get the kid we want, or when we get one we hadn't planned on. The recovery in a case like this one isn't for a bad kid or for a wrongful birth, but for the harm of confounded procreation. Advances in reproductive medicine and technology now promise to deliver us from the vagaries of the natural lottery. Freezer failures and birth control blunders may be first world problems, but these aren't innocent lapses or harmless errors. They're wrongs in need of rights. Thank you.
Great, thank you. And first, I just wanted to thank everyone at the Petrie-Flom Center for inviting me to share my remarks today. It's always sort of a surreal experience when you share the stage with the professor whom you wrote your law school admissions essay about. So I'm just really delighted to be here today. And I also just wanted to preface my remarks with saying that I'm going to challenge you, Professor Fox, to think about some critiques of your book, but overall, everyone should go out, if you're interested in this field, and buy this book. It's very well written, and it would be an amazing resource for any students thinking about doing research in this area, or if you're just interested in the field. It's a really excellent addition to the literature, so thank you for that, Professor Fox. So just a quick overview of where my remarks will head today. I'll just talk briefly, sort of giving a little more color to the regulatory vacuum that Professor Fox mentioned. And then I'll discuss sort of my take on why I think a regulatory scheme side by side, or maybe in lieu of, tort claims might be a good way to remedy or perhaps more importantly prevent some of the wrongs that have been discussed in the compelling stories that Professor Fox has compiled in his book. First, I'll talk about what I think is an example of a way to establish that regulations could strengthen the tort claims that Professor Fox presents in his book. And then second, to consider if is there some instance, particularly in the context of bringing claims under the premise of there being some professional misconduct, what that means for if the role of licensing is critical in order for claims to prevail, as Professor Fox has proposed. And then finally, to sort of query, especially in the context of procreation confounded, since there would be these sort of small amount judgments because of the way that procreation is frustrated in these particular cases, is it really the case that tort claims would be wildly inefficient in this context? So to give a little color to the regulatory vacuum that Professor Fox very concisely and describes in his book, in the federal context, there is sort of one legislative act that was put in place by the federal government to govern IVF or reproductive clinics, and it requires IVF clinics to report their pregnancy rates, but there's no incentive and no penalty, no carrot or stick, as Professor Fox describes, and it requires the FDA to screen for infectious disease. That is one of the sort of wins in this space, is that it is a regulation requiring that disease won't be spread through provision of gametes. But there's a big carve-out that touches a lot on these negligence claims, which is that they cannot control the practice of medicine. We see the similar vacuum in the States. There's some regulation of stem cells. Some states have enacted legislation regarding what to do with embryos in the event of a dispute, usually as part of divorce proceedings. Some have addressed surrogacy. Others have insurance mandates to cover IVF. And I mentioned sort of the Utah and Louisiana are examples that Professor Fox provides as well, and also describes a very lax-seeming Californian medical board in which there's a physician who has had multiple claims against his practice, and yet the medical board has not taken any actions. Finally, we have the professional organizations, the American Society for Reproductive Medicine and the College for American Pathologists. As Professor Fox mentioned, these are completely voluntary and have no enforcement mechanism. So I would gladly sort of pick apart my critique of these in further discussion if we'd care to go down that road, but simply note that there are some drivers that Professor Fox proposes are informing this regulatory vacuum. And in the book says that this is part of why we should go down the tort path. And so I think that regulation may be a way in which we don't have to choose one path or the other, and that's actually a question I'd love to explore more in our discussion, is the extent to which we could do both in this context, and if both would actually help. So one example that Professor Fox mentions throughout the book is sort of this ideas about intangible claims, such as claims to privacy. And one example of how we could create these types of claims is by relying upon other statutes, a regulatory statute, as illustrative of a standard of care which has been violated. We've seen this happen in a few states in regards to HIPAA, which is a federal law regarding privacy and doesn't allow covered entities or healthcare providers to share your personal medical information. And the enforcement mechanism for HIPAA is the Office of Civil Rights. So there is no private right of action. There is, under HIPAA, there is no right for you to go over to Brigham and Women's and say, I'm going to sue you because you sent my neighbor my medical records. The state of Connecticut actually recently heard a case that brought a suit against a Center for Obstetrics and Gynecology. And the Supreme Court of Connecticut found that there is the HIPAA requirements that were violated could be used as evidence to establish a standard of care. So the question I'd like to pose is do you think that regulatory schemes would help to establish claims that you, whether it be for confounding or confounding procreation or any of the claims that you propose? The other way that it could help when we think of the ingredients that are required for a successful tort claim would be if we had some, microchipped tracking mechanism that was required for vials of sperm or vials of eggs. Maybe there could be an easier way to pinpoint where the breach happened. So if we think of for especially any first-year law students, we think of a duty that's breached. We need to identify when the breach occurred so that we can, identify who caused the harm. So if we had this, perhaps maybe your claims would be stronger because you could point to that moment when your procreation was confounded because they took the wrong vial of sperm out of the freezer. And one of the more sort of complicated questions that comes to mind throughout the book, Professor Fox mentions that in these claims of negligence, when we think about medical malpractice and similar claims, there's a requirement that there be a professional standard of care. And that's how we litigate med mal claims, and it's how some of the cases that are described in the book come down one way or the other. And so you'll see I excerpt some pieces of Dove's work in the book, and so the question then becomes, how do we find professional? It's usually through some sort of licensing statute at the state level. So is it the case that in order to prevail, for example, against a California cryobank, which is not a medical institution as we generally think of, it's not a typical med mal claim, is there a prerequisite to establish these claims for professional misconduct of some kind, some sort of anointing of this group as a profession? And in the book, Professor Fox also notes that that's sort of how we would define the contours of claims that can be brought. So for example, the sexual partner who decides to use a knowingly defective condom would not be sued under the way that Professor Fox conceptualizes procreation imposed, that's how we could sort of draw those contours, is by saying it would be professional misconduct, and we wouldn't, for example, hold an intimate partner liable for, procreation imposed. Cutting the other way, however, maybe we don't, and maybe that would make these claims more likely to succeed because we don't have to license them. But and one of the cases that Professor Fox mentions is a case against Yale New Haven Hospital, for full disclosure, my former employer in the general counsel's office, that it in fact was a mislabel when a patient's reproductive materials were improperly disposed, that in fact it was this labeling incident. It wasn't at all a med mal claim. There is no standard of care to consider. It's just negligence. And on those grounds, the patient can prevail. So it seems like this need for licensing sort of cuts both ways. And I'd love to sort of tease that out further in discussion. I'll wrap up quickly because Carmela's telling me I have 2 minutes. 30 seconds ago. So finally, I have just similarly sort of provocative questions to say. You make a compelling case, Professor Fox, for sort of thinking very carefully about how we compensate these people who have confounded their procreation because the vials of sperms were switched, or for whatever reason, the traits that they wanted to select for weren't the traits that they ended up having in their child. And if that's the case, usually we think of in our system of torts as it being a really inefficient way to address a harm with only, a small damages award because the cost of litigation is very high. So wouldn't it maybe be the case that instead a regulatory scheme or some sort that would specify amounts, or maybe like HIPAA, actually not allow for private rights of action and allow the government to regulate it in a way that assesses fees, might be a whole lot more efficient. So finally, I return back to one of the cases that you discussed in your talk today as well, and just, sort of think all these types of claims that were brought against Zytex, negligence, fraud, false advertising, breach of warranty, battery by insemination, if any of those were legislatively defined, or if there were regulations that described these types of errors as, a violation of a standard that a state would set, how could the result be different? And I'd love to talk about that in our remarks. Thank you very much.
So thank you so much. I'm not sure what to plug that into, so I'm waiting to see if anybody can help me. But in the interest of time, I'll get started. My name's Louise King, and thank you so much for inviting me. I greatly enjoyed reading your book, Professor Fox. I read it twice. And I found it so compelling that I came up with pages and pages of notes of things that I wanted to discuss with everyone here, but I'm going to only focus on 2 points, obviously, in the interest of time. Just a point of introduction, I'm a physician. I also have a law degree, and I'm the director of reproductive bioethics at the Center for Bioethics. So I have my feet in a lot of the different areas that are raised in this book, whether it be the legal constructs that are proposed or the ethics that underlie our considerations here. But also, as a medical provider, I thought I should really share that perspective with you and what this would mean for me as somebody who actually works with infertile patients, most specifically as a surgeon, more so than in any other capacity. A lot of the cases raised in Professor Fox's book address things, for example, like a sperm bank that typically doesn't involve any medical professionals whatsoever. And we, as providers, would have no ability to control the information that that sperm bank was collecting. Or the product liability issue with oral contraceptives would also be something completely out of our control unless we noticed that it was packaged correctly. So my comments are directed more at what this would mean for me in terms of the practice of medicine and how tort liability would affect me as a provider. As a disclosure, my husband is a partner and a reproductive endocrinologist, a partner at one of the largest REI groups in the country, if not the world. And he's also the chair of the ASRM practice committee. So I should share that with you because it's very relevant to this talk. He would also wring his hands because he spends hours and hours and months writing up guidelines on professional conduct that he has no way of enforcing. So he'd be very much in favor of further regulation. And I have proposed in many different arenas that we need much more regulation. So I'm definitely on the same page as you in terms of that being the solution forward. And my argument for you today is that litigation would actually potentially hold us back. This was a paper that I commissioned from Baroness Ruth Deach, who was the head of the HFEA in England, which I think serves as an excellent model for effective regulation that's done not just from a legal perspective, not just from policymakers' perspectives, but it engages physicians, scientists, and the public in creating regulation that is effective in addressing the ills that are very beautifully outlined in Professor Fox's books. So as mentioned, ASRM has no oversight, CDC has very little. There's a poll that's cited in the book that is very interesting, and I'm going to start talking to you really quickly about medical error, because from my perspective, we're talking about litigation based on my medical error, and I want to just share with you very honestly the huge problem of medical error that we're all facing as physicians today. So this fertility IQ anonymous poll cited in Professor Fox's book said that there was a 30% clerical error rate in IVF procedures, mixing up the sperm, writing down the wrong test results. That number sounds incredibly high, but it's actually completely in keeping with the same rates that are reported in general medicine from the IOM reports. This is the level of medical error that we are facing in our country today, even in the setting of incredibly rigorous regulations for like hospitals and the like. So medical error in the United States, based solely on estimates, is the third leading cause of death in our country. It's less in other countries where they have national health services, but not by much, actually. And it's actually a function of how complicated medicine is. Other contributing factors actually probably are the electronic medical records that we're all forced to battle with day after day. I spend half my day inputting data into a medical record. So half of my time is spent doing that instead of taking care of the people who are coming through my door. And I get tired and I get burned out and I don't do it very well. And I make a lot of mistakes, and I'll acknowledge that right here. I make a ton of mistakes in the medical record. I can't help it. It's just overwhelming. And so this is from the National Academy of Medicine, and they're doing a lot of work around physician burnout and noticing that our clerical duties are actually contributing to this. We need to address it, and there are certainly many, many efforts underway to make it better. So I've taken some quotes from your book, Professor Fox, only insofar as I wanted to respond to them, not to like, call them out or anything, but just these are, I'll read them quickly. Doctors rarely make explicit promises. I don't. Reproductive specialists are savvy enough not to assure patients they'll get pregnant or avoid parenthood. We're careful to decline promising. The language implies that I'm intentionally holding back. I'm not. I'm just telling you the truth. In the setting of a 30% error rate, I can't even guarantee your safety in my OR. I do 300 procedures a year, and I personally, because I track it myself, have a complication rate of 1% to 2%. The national rate is 11% to 40% in my specialty. So my rate is awesome, yet you could still die on my table. So I can't guarantee your safety as a physician. Ever. I can't guarantee anything, and I never will be able to. There's a certain innate aspect of medicine that is just not open to getting to that level of perfection. So I just wanted to share, if I have time, and feel free to stop me if I don't, but a cautionary tale that came to mind as I read this quote. So it says, most obstetricians recommend cesarean surgery for difficult vaginal deliveries, but enough still use forceps or vacuum extraction. And then escape charges of malpractice based on custom. And I was struck by this, this language, and again, I may have misunderstood it, but it seems to imply that the use of forceps or vacuum extraction in obstetrics is a bad thing. And the reason I want to bring this forward as a cautionary tale is litigation was used in obstetric injury, birth injury, or obstetric violence is the new term for it, to push forward for changes in obstetric practice, which has actually backfired, and let me explain why. I think forceps and vacuum deliveries are exceptionally important in the safety of women's health, in their safe deliveries and the safe delivery of infants. The maternal mortality rates in the United States are abysmal, and it's partly because we can't use forceps. Let me explain why. So we have an appalling rate of maternal mortality. There are other factors. We have much higher rates of obesity. We have race-related factors that are associated with underlying medical conditions. We don't do enough good work on preventative health. We have an aging maternal age, like mothers are coming to pregnancy older, but that's true everywhere. That's true in the Netherlands, so that's not it. The maternal mortality rate has been creeping up since the 80s. You can, if you look here and then you drill down, you'll see that there's this little uptick around the late 80s, and that corresponds to about 1987. And if you look into when there was the hardest, biggest push for litigation in obstetrics, it's around that time. It's around that time that people started leaving obstetrics practice. We had fewer obstetricians because of the high malpractice rates. I have to pay $200,000 a year in malpractice. And it's because we couldn't use certain tools that we knew were important. And so looking at this graph, I don't have, if I have a pointer, I don't know where it is, so I'll start talking really loudly. But if you look here, this is spontaneous vaginal delivery. That's when you pull it off on your own, and yay for you. This is episiotomy, and we got rid of that, and that's a good thing. And that was related to litigation, so thank you for that. But this is where we had to pull away from operative vaginal delivery using forceps and vacuums. And this is the cesarean delivery rate going sky high. This country's cesarean delivery rate is massive, and what it contributes to in later deliveries is higher rates of a condition called placenta accreta or accreta, placental abnormalities that lead to maternal death. So if you push forward too hard on litigation without cooperating with your colleagues in medicine, you might have problems that you don't fully understand. Fetal encephalopathy is the condition of, that leads to cerebral palsy, and that is the equivalent of birth injury. That's the, thank you so much, 2 minutes, so I'll go fast. I think I can do it, pull it off. This is the task force that came together to try to figure out what was really going on, because our C-section rates went up, but our rates of injury didn't change. Our rates of maternal injury didn't change either. By the time we get to a C-section, if you're having a difficult vaginal delivery, we could injure you still, and frequently do. So this is what came out of that task force. I'm putting it there intentionally to show you this is what we now understand to be the cause of neonatal encephalopathy. It's incredibly complex. It has to do with all kinds of things related to many, many different things that could go on in birth and all through the pregnancy, not just at the time of birth. And we're making great strides forward now, but now we're also having to try to pull our C-section rates back. So I want us to become more partners in this, more partners in creating regulation that will address all the ills that are beautifully articulated in Professor Fox's book. And one last thought incredibly quickly. And you raised it, Professor Fox, at the end of your talk. What kinds of influence can prospective parents, this is a totally different direction from what I was just talking about, by the way. What kinds of influence can prospective parents reasonably expect over the characteristics their child is born with, if any, is what I would add to that. I think we're moving forward a little bit too fast and furious and creating expectations for parents that we can't ever achieve, especially in the context of not fully understanding what we're dealing with. So there's a discussion in the book about mosaicism and the transfer or not transfer of genetically affected embryos. We really don't understand all of this yet. We don't understand what it means when we take a single cell from a blastosphere and we know that that's abnormal, but another part of the embryo might be normal. We do check for all 46 at every chance we can get, check all of the chromosomes of every embryo, but that actually leads us to more false positives and more instances when we will tell families there might be a danger. And because of the threat of, the potential threat of litigation, reproductive endocrinologists are unwilling to transfer these mosaic embryos because they don't know what it means, or when families have come to the end of their reproductive journey, they may have 1 or 2 embryos in front of them, and only one, let's say, is potentially viable, but it's a trisomy 21 embryo or a Down syndrome embryo. We're working hard with reproductive endocrinologists to encourage them to still transfer that embryo if desired by the family, not to discriminate against families that wish to proceed forward with and I'm using big air quotes here, a genetically affected embryo, but they're reluctant to do so for fear of litigation. So you would, at the end of the day, you might limit people's options by pushing too hard for litigation, whereas with concerted regulation, we might move forward in a better way as partners. Thank you so much for your time.
I do not have an excellent success rate, and you cannot die on my operating table. That is like badass, what she said, right? Best I can say is, well, I'm a pretty good teacher, and maybe you'll get the sweats if I cold call you. Like, that's the highest range of what I can do. But I'm here, so I'm going to try and do what I can. So this book, I hated this book. Not true. Wouldn't that have been a dramatic way to start this talk? But I think the perspective, no, it would have caught your attention. But I'm not just being slightly facetious, because I'm going to talk about the book from the perspective of the kinds of people who will dislike this book and try to identify those people and see whether Dove has communications or things that he can say to them. First off, just disclosure, I too have a conflict of interest. I sit on the American College of Obstetrics and Gynecology's ethics committee, and tiny bits of what they do actually do influence some of this practice, so they're more focused on obstetrics and gynecology than the reproductive endocrinology. So, by the way, the book is for sale out there after the talk, so if it turns out you are so inspired, you might go buy one. Who are the people who will have a hard time with Dove's book, with Professor Fox's book? So the first question is, how do you feel about liberal eugenics? And what do I mean by liberal eugenics? You know, it sounds bad, maybe it's not. Liberal eugenics is the view that while old school eugenics were terrible and bad, liberal eugenics, the private decisions of particular individuals to make certain kinds of trait selections, are something that deserves honoring or at least toleration. And I think the book's kind of intersection with those who are uncomfortable with liberal eugenics is quite interesting. So the book begins with a discussion of donor 9623, whose sperm, as you're told, is sold as Tom Cruise-like, high Q, taller, PhD candidate. It turns out not to be true. There's another story in the book about a Portland jury who gave a couple $3 million when she had a child with Down syndrome that was not caused because of incorrect chronic villus sampling that was incorrectly performed. The unstated claim here, though, of the book is that these are injuries, and injuries that are quantifiable. Many people will find themselves discomfited from that, and the question is whether one can really be neutral on whether that's problematic and still endorse the tort regime. Tort is, deep down, extremely a normative, moralized idea all the way down. And it's hard to endorse the tort without moving to what we might consider to be a consumerist kind of idea of reproduction. That just like the classic Kingsfield cold call in the paper chase about the hairy hand case, Hawkins v. McGee, you were promised X and you were given Y, and that's a problem. And that might be okay when you're talking about a Chevy or when you're talking about a computer, but many people might feel themselves discomfited about that when talking about a person. And to me, the illustration that takes us to the place where I think I will stir up the most discomfort is a question about an incorrectly performed sex selection, sperm sorting, for example. You're promised a boy, it ends up being a girl. Do we think that ought to be actionable? How much do we think the damages ought to be? And in what way would we feel about that? So that's, again, a group of people who might feel uncomfortable. Second group might feel uncomfortable. Those who have trouble with genetic essentialism, right? This idea that we are our genes or that our genetic connections to our children are what matters. And Professor Fox is very careful. The book is very well written. It's very well put in this respect, not to slag adoption or to say there's anything problematic of adoption. But much of the impetus and much of the moral force of the book comes from the idea that our genetic connection with our children matters a lot. Therefore, when it is confounded, we have been injured a lot. That is, once again, you might say, a contestable premise and a premise some people are uncomfortable with. Now, again, I don't want to push this too far, and that most of us who can reproduce, who are not infertile, choose to have children who are genetically related to rather than adopt. Some of us don't. Many of us choose, even if we need a sperm or egg donor, we choose to use our sperm or egg as the counterpart so that at least one member of our reproductive couple will reproduce. But you might wonder again, for somebody who thinks genetic essentialism is exactly the wrong message to send to society that ought to be disrupted, how the tort regime's intersection with it might be problematic or not. The last group that I think might be discomfited or dislike the book, and again, it's a challenge, and again, all of these I think in some ways are traps for Dove, and for Dove to explain to these audiences why nonetheless his tort theory ought to prevail, notwithstanding these concerns. I don't want to claim it's open and shut. I'm just talking about the kinds of people who will find this book maybe a resistant read at first. Has to do with people who are concerned about reproductive rights in America. In that much of the tortification, if you will, of losses of embryos in particular, and losing here may strike people as uncomfortably close to legal theories that would imbue personhood to embryos and the like, and therefore restrict abortion rights. Now, to be completely clear, there's nothing that logically commits you to the view. If you believe that when a bank destroys your embryo, you ought to be recompensed, that doesn't logically commit you to the idea that when you destroy your embryo, or when your spouse destroys your embryo, or when your spouse has an abortion, that you ought to also be recompensed. It's not a claim of a logical necessity. It's instead a claim about political reality. And whether the endorsement of these theories are the camel's nose under the tent, and create an opening for political use of this to build cases that are going to be ultimately restrictive of abortion rights and the like. Now you might say, so what? That the heavens fall, we ought to do the right thing, and we ought to do the right thing for these families. But in particular, I'm very interested also about the way in which this rehabilitates an idea of paternal rights and father's rights, because on Dove's theory, it's not just the mothers who get recompense for these losses, but also the fathers. And once we say, and perhaps this is correct, gender egalitarian, the father's interest and the mother's interest in these cases are very similar, then you start wondering where else we might think they are similar and whether that is problematic or okay. The last people who might not like this book, and this is one he directly engages with, is tort theorists, right? And many tort theorists have some problems with this idea, in particular, this question about whether the claim of the book is that reproduction is special. I want a small alteration to right a wrong in the area of the tort of reproduction. Or whether the book is a much more radical claim that much of our tort regulation or tort treatment of intangible claims about things like emotional distress is wrong in a deeper way, such that it's not just examining the small piece, but wanting to examine the big picture. And I think what's fascinating in the book is that it opens up a whole bunch of very interesting and difficult questions, which I think will make, if this ever becomes the law, will make decades worth of tort final exam questions, right? So here's just a few of them to think about, right? Imagine that there is a woman who has frozen her embryos at age 25. And imagine in World One, the freezer failure happens when she's 25. In World Two, the freezer failure happens when she's age 60. Does the amount of compensation she is due, should that be different, even though it's the same freezer failure, based on the fact that her chance of reproduction has decreased? And if the answer is yes, is there a problem in terms of a gap between the compensatory function of torts and the deterrence function of torts? Because you might say our interest in deterring the freezer failure is exactly the same whether it happens now or later. Another interesting question is a woman who happens to be married to an infertile man, does her ability to reproduce, recover here, because again, the chances of actually reproducing for, let's say, frozen eggs is less if her husband also had an infertility problem. Should she recover less than one who is married to a fertile man? What happens is, if in between the freezer failure she divorces and remarries, does her money still go up now or go down? I can keep going. But just to say that I think what's great about this book is that it opens up this generative thing. So while I focused on 4 groups who might have trouble with this book, my goal is to show you what a wonderful book it is, because this book, I loved it. But even if this is not the book for you, even if you fall into one of these 4 categories or other categories, you will read it, you will keep wanting to disagree with it, and then he'll say something beautifully and persuasively, and you'll say, maybe I should think about that again. And then you'll get angry again, and then once again you'll say, maybe there's something here there. It beautifully connects pathos, human stories, legal theory, amazing amounts of research, and it's a wonderful read. So I highly recommend it to you all, and with that, I'm done. Thank you.
All right, we now have a short amount of time for audience Q&A, so I'm going to ask the panelists to take seats, and Dove, you can stand in the hot seat, so to speak. Before I turn over the podium to Dove, I just want to remind everybody that we are looking for questions and not statements. You can generally tell if what you're about to say is a question by whether it might have a question mark in the first 2 lines of it. And so with that caveat, I welcome people to line up at the microphone and ask questions either of the panelists, of the responses of the book, or to ask Professor Fox questions about this book.
Great. And Dove, you get to stand there. No questions whatsoever? Oh, you want to say a word or two?
Yeah, well, first of all, I am a bit overwhelmed with gratitude to Katie Crashel, Louise King, and Glenn Cohen for their generous and careful engagement with this project and the ideas. Thank you very, very much. There are a number of points you raised that I would be very glad for the chance to answer, either now or later, but as we now have some questions, why don't we start here and come back? Please.
So this was all really fascinating. I love the back and forth and the engagement, and that was great. And as I was listening to it all, I was thinking about, I was thinking both about the hairy hand case, or bargaining for a donkey and getting a mule, that kind of thing. And also some of the cases that you bring up, things, I don't know if it's in the book, but like there's one of these cases, the Harnacker case, where it's a similar kind of a sperm bank mix-up, which feels a little less egregious than your Tom Cruise example. But trying to sort through then some of the things about what's happening if you're an OBGYN versus the Tom Cruise Xilex or whatever that place is. And the role that commodification is playing in all of this, and where then torts fits in. Because there is, and I just sort of want to get I guess just your sense or reaction to this, anybody's, about drawing a distinction between the kinds of malpractice that might happen in a wrongful birth or wrongful life case, where there's medical, you might argue there's some sort of medical malpractice, a misdiagnosis, but in the context of a therapeutic relationship where, sure, it's fee for service, but it's not, the traditional doctor-patient relation is traditionally not a commodified relationship. But what's happened in the last 20 years, 20, 30, 40 years, is the emergence of the commoditization of reproduction, right? The commodification of it in a new way. That's not the same thing as simply a doctor charging for services. And do you think different standards could or should be developed to apply to a more commodified context like Xilex, or again, whatever they were called, versus what happens when you just miss a trisomy or something, and the people are born with a kid with Down syndrome that they may have, or at least they feel deprived of the choice of the ability to make a decision whether or not to carry to term. So, so it's just basically about thinking about, is it all just sort of one regulatory or tort regime, or should maybe things be fleshed out, whether it's a fundamentally sort of commodified nexus or a caregiving nexus, whether that makes a difference?
I confess I don't fully appreciate the distinction that you've drawn, but I think one of the challenges that I grappled with in the book is whether we think about professional reproduction more broadly as a traditional medical practice or like a consumer good. And idiosyncrasies of our reproductive politics emerging after the birth of the first IVF baby in the late 70s in the UK saw to it that the industry, at least of assisted reproductive technologies, developed much more like a consumer good, like a market enterprise that would sound more in this commodification register than oncology or any other area of medicine. And I find that to be a mistake. I think it is, but it's part of a much larger conversation that we're having in this country about the meaning and character of healthcare as a right or a privilege or otherwise, and where reproductive healthcare or practices that help to avoid or enable or somehow shape reproductive possibilities fits neatly within that scheme and conversation, or whether it's something different.
Hi, yeah, so perhaps somewhat relatedly, I'm wondering about if you have a case against regulation, bearing in mind colleagues from the comments from the medical side, or if it's just that you don't think we'll ever get it, or if you think tort will get us stuff that regulation just wouldn't, and we should go forward with tort, even if we had a good hope for regulation.
Regulation in this area, I think, would be fantastic, and I confess I don't understand the resistance, or at least I don't understand the justification for the resistance to regulation by professional societies. I think the claim is something like we do good enough already on our own by self-regulating, or that it would be much more costly for us to be required to undertake certain safety protocols and other sorts of mechanisms, and then we would pass those costs along to our patients, who would in turn be less able to access these valuable activities in the first place. Or that regulation might somehow stifle innovation in this area that is so cutting edge and requires really, fast advances. But I think greater regulation than we have to prevent the sort of what strike me as really shocking errors and mix-ups that take place would, at a minimum, be wonderful. It's just very basic licensing and reporting and inspection mechanisms, for starters. And I think that would be great. I have nothing against regulation, and I'm all, whether regulation would authorize by statute cause of action in the way that Professor Krashel proposed, or more traditionally, like the fertility fraud statutes that we've seen recently in Indiana and Texas that say, well, it turns out there was no law against a doctor you go to have a donor sperm used to help you create a child using his own sperm instead, not telling you, and that's just okay. And so these states then have passed some laws to address that, to provide a cause of action in some cases, or to make it a crime in others. And there are goods and bads of each of these in this particular context, but to suggest that this is a model for how regulation might proceed in a limited sense, I think that would be great. The only reason that I'm 3 cheers for tort law in this paper is really as a second or third best solution. 1 would be regulation in a more traditional sense. 2 would be to use existing causes of action. But none of them are sufficient, and all of those avenues have been closed off for various reasons, whether statutory carve-outs or legislative inaction, or judges say it just doesn't fit quite right. And so this is really just the next available option. That said, I do think that torts serves a pluralistic function that can be useful, and it doesn't have to be so single-mindedly focused as Professor Cohen asked, on either deterrence or compensation. I think it's very plausible to have a pluralistic view about the goals of tort law, to deter and to deter wrongdoing, and to compensate victims, and to send a message, to society about what kind of conduct we regard as wrong and what sorts of remedies are demanded by way of rights.
Hey, my name's Kearney, and I'm a 1L, and I wanted to thank you all for fabulous presentations. You've given us a lot to chew on, and you've hit a lot of buzzwords that were in classes today. So I think from what all of you have said, one of the things that really stuck out to me was the under-regulation of IVF clinics stands sort of in stark contrast to what I'd call the hyper-regulation of abortion clinics, and whether or not you think that like either regulation or through tort law and prosecution, you'd have a better, if either of them sort of have pros or cons for addressing that discrepancy. And obviously there's a very moral element to, like, baby killers versus baby lovers, but kind of creating more of an equal playing field between these two providers that are offering what I would say are quite similar services, just on different sides of things.
Awesome question. I think it connects with Professor Cohen's concern. I think this was the third group of people who won't like the book, about implications.
But ultimately we'll love it. They just initially won't like it.
We'll have a bad first reaction, and then come to appreciate the wisdom of everything written. Yeah, that I think it is. It's a really odd. It's a really odd juxtaposition. As I think you put it beautifully, the hyper-regulation of abortion clinics, the under-regulation of IVF, and yet they're both kind of in the business of something to do with reproduction in babies. Why is that? Well, that's a very complex question involving religion and morality and politics in this country. But you're right that if you put these rights of procreation on some kind of even playing field in the way that I've suggested, to say that they all they're different, but they all fundamentally implicate three really big moral values, and we should treat them generally sort of the same, or at least in the same category. And I think that's a really good question. And one way in which I think the proposal's gesture is precisely to treat these different areas of reproduction, notwithstanding the very different kinds of implications they raise, on a more even playing field, and to call out that bizarre transparency, disparity, and ask why it exists and what would justify it. Very briefly, and I'd love to turn it to Professors Krashel and King and Cohen. I think it's a really interesting question. It's just the three goods at stake in both these areas, I think are, and this also is a partial answer to Professor Cohen's challenge about liberal eugenics. Why, in a case in which your reproductive choices for particular traits are thwarted, well, then you've got a choice. Are you going to provide a remedy or not? And should you have a thumb on the scale of not and suggest, well, no, you shouldn't be able to pick your kids, or in favor of remedy in a way that suggests, well, you've got some legitimate interest in the way that the law should stand up and protect you. And the reason why I think the default should be in favor, although there may be some cases, and sex selection may be one, where the policy reasons would suggest not to, are because it serves one choice or autonomy or making life decisions in a way that you call your life your own. You are the author rather than just a protagonist of your life. But it's not just about choice. It's also, I think, about well-being. Independent of you choosing these things for yourself, the choices you make about reproduction make your life better. Why do you choose to have a child, or to have one now, or not to, or to have a child of a particular type? It's because that has a far-reaching impact on your life that you think, and you're probably right, is going to make your life better or worse for you. And finally, because people's reproductive prospects, both to avoid and to undertake reproduction, are so very different by virtue of our different genetics and circumstances and so forth, it puts people on a more equal playing field when these chances are equalized a little more. And to deprive them of these kinds of remedies is suggest, well, that natural inequality is just fine, leave it be. And so all those reasons, I think, suggest why these, just to say, I think you're right, and I think we should treat them more equally, at least to the extent that these very basic fundamental human goods are implicated. Would others like to weigh in?
I'll say one word, which is to say, I think what's interesting is that when non-progressive forces have overreached, like the Mississippi Personhood Amendment, part of what helped defeat it, even though it's aimed at abortion, is when you start, don't touch my embryos is kind of a feeling, I think, about many people, and even many conservative people. And there's a way in which almost everybody in America now, not true years ago, has a sister or a brother who has used a reproductive technology. And there's a way in which I think the reproductive technology community are an important ally. But, and here's where it gets interesting, I think, and this is a little bit of a controversial, that if you look at the population that performs abortion and the population that performs reproductive medicine, the abortion doctors are doing God's work, everybody respects them, but they don't particularly want to be closely associated. And even in the terms we use, like selective reduction, which is essentially a form of abortion done as part of IVF, we call it something different because it's very important to have this distinction and this boundary. So I think there's some interesting questions about respectability politics here.
Yeah, and I would just, one of the clinical lecture part of my title is because I co-teach the Reproductive Justice Clinic at Yale Law School, and I would say if you look carefully at the statutes that were enacted over the summer, like one ban after another, at least one of them, I'm not recalling which right now, was very explicit about the personhood right that they described beginning at the point of implantation. And I don't think there's much of an explanation besides the fact that they want to keep their IVF babies. And as far as just real quickly about sort of overregulation, the right amount of regulation and not enough, when I pick apart the different players if I was to do Dove's book, my point of entry would be more to talk about the different players on the sort of public-facing side, and I don't think that necessarily IVF clinics are underregulated. I think abortion clinics, you're spot on, that they are overregulated in some states. And I think what's terribly underregulated are the for-profit gamete banks. And I would just query the audience to consider the story that we heard about the Zytex donor, seller of his sperm. Would we feel differently if they had still failed to screen for these things, but that public-facing profile of the sperm that was being purchased wasn't so glamorous? It was a nonprofit bank, and they just listed things that were clearly heritable, like height, or eye color, things like that are less sort of sensational. How would you feel differently, if you would, about claims against that bank?
I don't have anything to add.
Great.
My name is Isaac. I'm another 1L. There's a run of us now. I have a question probably relating to Professor Cohen's second class of people. So my professor in undergrad just published a book on private racism, and called Private Racism, and he shared a chapter with us before it was published, and I assume this chapter made it in, where he argues that sperm banks shouldn't be allowed to disclose the race of sperm donors at all, because there are expressive, implications about a certain racism that's being supported by that. I don't necessarily buy that, but I think it's convincing. And if you allow torts to enforce wrongs, you're putting the courts in a position, right, where they're like, defending this racism. They're adjudicating that racism. How do you respond to that? Is that problematic, do you think?
That's a really tough case and a great question, and it's not a hypothetical one either. One of the cases that the book takes up was from 2014 out of Ohio. A lesbian couple, they were both white. They picked a donor who was, like them, white, because they didn't have the kind of tracking mechanism that Professor Krashl proposes. Instead, they used pen and paper to take down the order, as it were, donor 180. Well, it got scribbled out or smudged, and they ended up with donor 80, who was African American. And then the baby came out with conspicuously African American, or stereotypically so, conspicuous features. Then they wanted to sue the sperm bank for precisely the mix-up, I think, that you're suggesting may be very problematic. In that case, as a matter of state doctrine, it was pretty easy, open and shut, like it was in the Zytex cases in the state of Georgia. No wrongful birth. You can't complain about anything to do with your birth of your child, because your child is a blessing. You don't get to complain, and you should be grateful you have any child, especially if you have a healthy child, so the courts say, and that is that. You have no ground for complaint, not under the law. But I would suggest a different answer, one that is nevertheless complicated, I think. It is to provide a cause of action to sue for confounded procreation in service of those three goods I mentioned, of choice, of well-being, and of autonomy. But only offspring selection simpliciter, only generally, only this kind of basic idea that you have some interest in choosing certain traits of your child to be. And accordingly, because it would only be that very basic interest that would be appropriately remedied here, the corresponding damages would be relatively low. It would be a small baseline amount, a very small amount of money that would specifically be targeted. And this also, in part, goes to your question about the implications for fetal personhood, because your implication is, well, if you're going to provide a remedy, doesn't that mean that the court is saying, as a matter of law, that getting a black child is worse than having a white one, or that multiracial families are worse than monoracial ones, or some similarly offensive, insulting kind of message that we certainly don't want to send as a matter of public law in this country. And I think that's a very worthy concern, but I think that we can provide a small remedy in part to serve that deterrent function of court law and try to be really, really clear about what that money, what the remedy is for and what it is not for. To say there's a small amount of money we're giving for selection interests generally, full stop. This is not for the fact of your thwarted efforts to have a child of a particular race, because I do think the policy interest would be too troubling to provide any kind of remedy for that. And I think that you can provide some deterrent function, that is not say that, well, sperm banks or egg vendors can make any mistakes they want just so long as the mistakes they make implicate interests that are implicated by policy. But nonetheless, try to steer clear of some of those more troubling messages that it would, I think, very plausibly send. And I think we can do the same with worries about fetal personhood, to say, well, we protect somebody's interest in reproduction, which is not because embryos are persons, but because we think that adults who are interested in having children have worthy interests. And we're protecting those interests not because we value non-traditional families any less, or that they flourish any less by virtue of a family through adoption or step-parenthood or whatever than nuclear families that have genetic affinity, but that for people who value that, they have a not illegitimate interest in having those respected, vindicated, and not thwarted negligently without any kind of regret.
So can I tell you two things? First of all, am I right in remembering this was the subject of your Yale Law Journal or Hastings Law piece 10 years ago, right? It's the exact topic of this chapter. So that's just going to show you when you're a student, you write something good. Maybe 10 years ago, you write a book. So all of your students consider publishing your writing. Second thing, much less interesting, which is to say we're almost out of time, so I'm going to recommend we take the last two questions together and then have an answer to everybody, and then we'll finish. Will you two give your questions first, and then we'll have the answer to both.
Practitioner, and I've been in my field for 35 years, and I have met many a parent who's had a child with something such as Down syndrome and would say, yes, we were shocked, and yet we wouldn't trade her for anything. She's brought such joy to our lives. I've had other patients who went through the heart-rending decision to terminate a pregnancy because they determined it wasn't right for them. My concern is that as we use more and more genetic testing, people will have an even greater false sense of security from having whole exome sequencing, karyotyping, all these different genetic tests that are done, that they're going to have, quote unquote, the perfect baby. And when the athlete has a kid with 2 left feet, they're going to be really disappointed. And what's happening now is so many people have this expectation, everything's going to be perfect. Are we going to get to the point where you'll sue your providers because you had all the tests and everything was supposed to be perfect and it isn't? Where are we going to draw the line? I mean, Finland is virtually on the cusp of eliminating Down syndrome. I can't imagine what it would be like for a family in Finland that chose to carry a pregnancy with Down syndrome, because they have like 99% termination of children or of pregnancies affected with Down syndrome.
Let's take the last question.
Well, taking a step further, if governments can regulate means and methods, or even if you can compensate someone for the consequences of malfeasance or malpractice or whatever, can governments actually regulate reproduction itself? If a government, for instance, wanted to limit procreation to 1 child per family or less for environmental or other reasons, would that be permissible? Is there any real inherent right to reproduction in itself for human beings?
Great. On the first question, if I could defer to Dr. King, I think that it's a fabulous question, and I share those concerns. Maybe you can speak to them. I know much better than I could.
Well, I think building on the comments that you made that were about the question about condoning racism, to try to summarize it a little bit, would these legal remedies somehow get into the realm of that. I think it does in that way. So as we protect a family's ability, which I do personally protect, a family's ability to come to me and say, I'm not ready for this pregnancy, I am also, in some sense, buying into the social decision that we are all trending towards, that we do want fewer people with that disability. And I think we're losing something in that, and something potentially intangible that we're not able to fully quantify. You do a beautiful job in the conclusion of your book of telling the story of one of the families that had a child affected with schizophrenia. And this girl was a pianist, and she was incredibly talented. And then one day she sort of disappeared off the planet, and was, her family, she wouldn't respond to them, and they lost track of her for months and months and months, and then she ended up hospitalized. But what I think we're losing track of is that there are many abnormalities within the human existence that we describe as abnormal, but we don't fully understand what they mean. So that young woman may have been exceptionally talented as a pianist from a neuropsychology and neurobehavioral standpoint, in part because she was going to develop schizophrenia, and we don't know for sure that that's not true. So again, the policies, whether they come through regulation, whether they come through tort, or whether they come through the ways that we support families through counseling in our practices, translate into the situation in Finland eventually. And we need to think about where that's leading us.
I'd be happy to take it up, but do we have time?
You have the last, yep, you get the last word.
I think those are beautiful reflections, and just right. I would only echo them and to suggest I think there are real costs of the proposals that I raise. In the case of a race-related switch or sex selection gone wrong, as with thwarted efforts to select against or even for, some kind of what we would refer to as a genetic disability, to recognize those efforts to choose as some kind of right under the law really sends potentially a troubling message. And yet, where does that lead us? Does that mean that then these interests must go unvindicated? Well, I don't think so. It strikes me that there are a panoply of enterprises outside of the courts. Certainly judges can use their words to articulate reasons that will try to steer clear of the more troubling implications, but we also have public education and regulation that can go a long way toward trying to moderate parental expectations for their children and understandings about genetic affinity or essentialism, and efforts to make choices that we don't think are good for us, or that people shouldn't want, or they shouldn't at least have to feel social pressure or soft coercion to make if that's not what they would, independent of what choices others are making. These are real costs that I think are worth facing head on in the context of a larger scheme that I hope can address them as we try to vindicate these worthy interests in the ways that we can. Thank you all so very much again.